Cooperative Governance and Traditional Affairs. So we can start with the meeting.
Thank you very much. Good morning, honorable members. Morning, the Department of Home Affairs delegation and COCTA delegation, the Parliamentary Legal Services and the Chief State Law Advisors. Our meeting is not going to take long, as we know that we still have a standing different opinion in terms of the clause in the marriage bill. And we have requested that the two departments come and brief the portfolio committee. We've been grappling with this area for some time. We afforded an opportunity for the department, the legal team of Parliament to have a conversation, and they did had a thorough discussion. As a result, they could not agree on the interpretation of the position they are holding, or the position that the Department of Home Affairs is proposing. Though they're using the same or quoting the same case law. So we requested that the COCTA may also assist to brief the committee, and then we'll have a way to facilitate moving forward a discussion. This is an important bill that we've facilitated public participation. And we know that once we have solicited clarity, we'll then have to have a conversation as the portfolio committee for a purpose of processing the bill. Secondly to that, there was also an area we have requested the department to look at in relation to the time frames. No, I mean the legal team, the time frame on when we need to conclude this process. The committee is sitting with too many items that we need to process, and part of it is a marriage bill. And I think also the current issues that we are grappling with, we've observed the president's input in relation to the current migration issues. And part of or most of the issues the president has articulated are issues that this committee, as a collective, have made recommendation for a period of time. Even in our budget votes, our engagement with the portfolio committee, I mean the Home Affairs Department and the Border Management Authority. And these are the key areas we need to ground in monitoring and the contribution of all members of the portfolio committee around this subject matter. So this is a short brief session that will allow us to process these matters. Thirdly, we know that we are approaching the local government election and the voter registration weekend. And the Independent Electoral Commission must brief joint committees that are responsible on the affairs of the elections. The Portfolio Committee of Home Affairs, Select Committee of Security and Justice, and COCTA. We are facilitating that joint briefing so that when we go to voter registration, at least the issues that you raised when we were presenting the annual report and any other related matters in preparation for the voter registration in particular, were able to ascertain that things will proceed well, and identify weaknesses that may arise, so that we have a conversation with the committee. The IEC has requested that because the brief three committees, it will be important that we brief joint to avoid time and limiting the committees to have information on all the issues. So we'll then move to the second item. I will request to ground my camera because I'm in transit, so I wanted to facilitate outside the video, and also the network is a bit compromising. Can I now invite item number 2 to recognize apologies?
Yes, Chairperson, I've got 3 apologies. That of Ms. Mohammed, the Minister of Home Affairs, as well as the Deputy Minister of Home Affairs. The Minister he has indicated that is on a family responsibility leave, and then the Deputy Minister has got another engagement at the same time. Thanks, Chair.
Thanks very much. All apologies have been noted. Can we move to item number 3? We'll deal with item number 3 and 4 at once. We'll invite DHA and COCTA. Then members will comment. And when we're done with these 2 items, we'll release the team and we'll deal with the last item. Department of Home Affairs.
Good morning, Chair, and good morning to the members of the Portfolio Committee, as well as my colleagues from the Office of the Chief State Law Advisor, Parliamentary Legal Services, and COPTA. Chair, I just wanted the meeting to note the apology from the Director General. He's attending a security cluster meeting related to migration issues.
Apology noted. We can proceed.
Chair, thank you. And once again, good morning to you, Chair, and members of the committee. Chair, you would recall that we starting at the time when the both Oxlade did not certify the bill, but submitted a 273 rule letter indicating the reasons and the rationale for not certifying the bill. The committee will also recall that we had briefings related to clause 628, more primarily on the proviso dealing with an exclusion or a matter to say that in the event that a written consent is required as far as polygamous marriages are in relation to the royal family, that the written consent would need to be obtained following the cultural practices or customs of the particular group from which the wives or the husband belongs to. Chair, you would also recall, and the committee would recall, that both the Parliamentary Legal Services and the Office of the Chief State Law Advisor had then made presentation to the committee and clearly indicated the position from which they came from. Chair, we are now coming back to just again to assist the committee in relation to the issues that both the Parliamentary Legal Services and the Office of the Chief State Law Advisor had then raised. Primarily, Chair, we just need to deal with whether or not the proviso, looking at Section 36 of the Constitution, whether it is justifiable under the circumstances and whether it is necessary to have such a proviso. So, Chair, in slide 4, we just dealing with the purpose of the presentation today, just to indicate that we want to present to the Portfolio Committee on the rationale for the retention of the proviso that in clause 6 to 8 of the marriage bill. Chair, we just dealt in the next slides, slide number 6 and 7. We just reiterating what the clause is all about, and it is primarily related to the requirements for polygamous marriages. And when we zoom into clause 6.2a, it requires that a husband in a marriage who wishes to enter into a further marriage after the commencement of this act must obtain written consent from his wife, or in the event where there are more than one wife, from his wives, as the case may be. The contentious issue here is the proviso, wherein we indicated that provided in the case of a royal family, the consent must be obtained in accordance with the customs and tradition of such family. We reiterate that the Office of the Chief State Law Advisor was unable to certify the bill on the basis that their view is that this proviso is unconstitutional and therefore it should be deleted. In the next slide, we reiterate what the Office of the Chief State Law Advisor had then indicated in terms of the 2793 rule. And just to reiterate that the Office of the Chief State Law Advisor in its presentation had then indicated and the various judgments that affects issues related to equality, issues related to obtaining written consent. And in the main, the Office of the Chief State Law Advisor was of the view that the proviso in clause 6.2a, which seeks to provide an exception to royal families, may not withstand constitutional muster, because in their view, it is inconsistent with the Constitution. Again, in the next slide, we just reiterating what the Parliamentary Legal Services have indicated in their presentation, and we're not going to get into this, safe to indicate that they are of the view that they agree with the Office of the Chief State Law Advisor that the proviso discriminates on the right to equality and human dignity insofar as the women married in royal families are concerned. And it was also of their view that the proviso may not and will not pass the constitutional muster. So, Chair, in the next slide, we just trying to submit to the Portfolio Committee, and by way of the various cases that we have had a look at, just to indicate how traditional councils or how kings and queens are identified in terms of customary law. And we then wish to draw the attention of the committee to the Traditional and Khoisan Leadership Act of 2019. And we just wish to indicate that in Section 8.1 of that act, it clearly indicates how our kings and queens should be identified, and clearly indicates that such an identification must have due regard to applicable customary law and customs, and that to identify a person who qualifies, in terms of customary law or in terms of customs to assume the position of a king or queen, as it were. Then in the next slide, Chair, we just want to point to again to the judgment of the High Court in relation of and the Supreme Court of Appeal in relation to the case that was before them in the Prince Bekuzulu matter with the presidency and others, and we just want to indicate, and again we are reiterating the fact that, or laying the basis that when we come to the necessity and just justiciability of the proviso, that it has to be that the committee must take into consideration that there is a difference in dealing with matters related to consent within the royal family, and we indicating that the ACA in paragraph 45 of the judgment then indicated, and they were dealing with the Zulu custom, and they have indicated that a queen born of royalty takes precedence over any other queen or wife of the king. It is also settled in customary law that the queen born of royalty for whom the nation paid lobola is the bearer of the king to ascend to the throne after the death of the reigning king. The Zulu nation paid lobola for the late queen, and the payment of lobola by the nation to secure the betrothal of the late queen to the late king served as a guarantee to the Zulu nation that the firstborn out of that marriage would be the successor to the throne. So, Chair, again, we're just indicating that when it comes to the royal family, there are certain rules and certain customs that will need to be followed in terms of designating or indicating the status of the wives within the royal family, and therefore that it becomes necessary that issues related to written consent should be left to the royal council or to the traditional council to deal with. Chair, again, we in the next slide we then quote another court case that is currently underway, and this is dealing with the Mpepu Ramabulana dynasty. And again, you would see, Chair, that the issues centers around who is the king bearer within the royal family and the principles and the rules that needs to be followed in terms of that. And you would recall that, Chair, we had then made an example prior in our previous submissions to the committee, that in terms of the vendor customs, again, which is similar to what we have indicated in the in Prince Bekuzulu judgment, that the key issue is whether or not the wife is a Zekiso wife or not, and here it is clear that the Zekiso wife is the traditional wife of the traditional leader selected by the royal council in the vendor custom, and that then becomes the person who bears an heir to the throne. So we are then of the considered opinion again that we submit to this committee that taken when consideration is had to the rules and the principles that are followed within the royal family, that it becomes necessary for the issue that is dealt with under the proviso, that it be left with the royal family itself to decide and to deal with. So, Chair, in the next slides, we just trying to indicate that when we have regard to Section 36 of the Constitution, we just need then to deal with the issues that have been raised, just to indicate that when we look at the principles that comes out from the judgments that have been decided relating to Section 36, but also to Section 36 itself, that we want to show that indeed the proviso is necessary, that even though it may be perceived to be unconstitutional, that it seeks to preserve customs, it seeks to preserve customary practices. So here, Chair, we're just indicating and reiterating what Section 36 of the Constitution looks at, and it provides that the rights in the Bill of Rights may be limited only in terms of a law of general application, and we believe that the Marriage Act is that law of general application because it applies to each and every one within the Republic, to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, freedom, but taking into account all the relevant factors, looking at the nature of the right, looking at the importance of the purpose of the limitation, the nature and extent of the limitation, the relation between the limitation and its purpose, and whether or not there are no less restrictive means to achieve the purpose. Only then, if the limitation meets this test, can then be regarded as being reasonable and justifiable. So in the next slide, Chair, we are just simply indicating, reiterating some of the judgments that have dealt with issues related to limitation of rights, and we agree with both the Office of the Chief State Law Advisor as well as the Parliamentary Legal Services that the Pharmaceutical Manufacturers Association judgment becomes important in dealing with this. And just to reiterate that in making a decision, courts always look at whether or not the decision is rational, relating to the purpose for which the power is given. So in actual fact, that we need to look at the rationality of the decision, in this case the proviso itself, and whether or not there is a government purpose that needs to be served by having this proviso, and we are of the opinion that it does. Again, in the next slide, we are just reiterating that when you look at Section 36, we also need to look at the Huxon rules that were decided in Huxon versus Lane. And again, we in order to decide whether or not something is unfair or constitute unfair discrimination under South African constitutional law, we need to assess whether a measure differentiates between people, and if that is the differentiation is discriminated based on specified or analogous grounds, and if that discrimination is unfair based on its impact. So basically, in the Huxon judgment, the questions that we would need to answer is whether or not the provision or practice differentiate between people and categories, and whether or not such differentiation amounts to discrimination, and whether or not such as then may be regarded as unfair. So those are the issues that we would need to look into. In the next slide, Chair, we go back to the certification judgment. Just to indicate that and in the certification judgment, the certification of the Constitution of the Republic of South Africa in September 1996, the Constitutional Court, in dealing with the limitation clause, then indicated that we need to look at whether or not such a limitation is necessary, and if it is necessary, whether or not such limitations are or is reasonable and justiciable. And the necessity will also show that it is necessary under the circumstances, as we wish to preserve custom, and we need to present customary practices, and that we do not need to go and change what is already there. Again, the next slide just simply in a nutshell reiterates what we have indicated, that we need to look at the proportionality and balance the different interests, but again looking at whether or not a limitation is necessary. When we come back and we deal in the next slide looking at now what Section 36 has indicated, that we need to look at the nature of the right. And we believe and we submit, Chair, that the rights that are involved in this matter relates to equality, human dignity, but primarily it centers around the ability of a woman to make an informed decision and to be able to communicate such. The other rights that are affected relates to the right to culture, cultural and religious rights. And we believe that clause 2.8, as it relates within the royal family to the issue that we are grappled with, relates to whether or not a woman within the royal family would be able to make an informed decision and would be able to communicate such. So we believe that in this manner, that the customs that are followed within the royal family would need to take care of this, and that this should be left for the custom itself to deal with. So the importance, when we go to the importance of the limitation, again, we are just indicating that the importance of this proviso is to preserve the cultural and religious rights as it appears in Section 31 of the Constitution. And we again just point the Portfolio Committee to the Prince Beku Zulu judgment, and just reiterate that core within the royal family is that is the core customary institution and structure consisting of immediate relatives, is that these issues relating to how kings and queens are identified and what are the issues that they would need to take into consideration should be left to the royal family itself. And that we submit that the proviso in clause 6.2a seeks to protect these issues on how kings and queens are identified, but more primarily to secure and preserve customary rights relating to customs and cultural and religious beliefs. And we also, in the next slide, Chair, submit that when we are looking at the nature and extent of the limitation, we submit that indeed the nature of the limitation simply deals with how a woman would be able to make an informed decision and to provide written consent in the event that the husband wishes to take a further wife. We agree that that is the nature, and that the extent of such is that within the royal family, that would be limited to the customary practices within the royal family and how they then identify queens and queens, and we believe that the purpose again is that cultural and or customary practices must be followed in order to fully comply with what the Traditional Leadership Act then provides, and that we are of the opinion that again looking at the nature and the extent of the limitation, that the proviso is necessary and should be retained. In the next slide, we're just dealing at a high level with the relationship between the limitation and its purpose, and we are of the considered view that the proviso is in line with the purpose of the limitation, in that culture and cultural or religious practices must be maintained and respected. We again reminded of the provisions of Section 7 of the Constitution, which obligates the state to respect, to promote, and fulfill the rights that are contained in the Bill of Rights. We believe, Chair, that there are no less restrictive measures to achieve the purpose. and that if the proviso does not appear in the legislation, that the effect of that would be that the consent requirement would be applied strictly within the royal family. And this, in our view, may have an unintended consequence as it relates to how queens and kings are identified. And it may also have an unintended consequence of diluting the customary practices and customs as they are practiced within the royal family, and that it is best left to the royal family itself to deal with issues related to how consent would be provided and how it would be dealt with. So, Chair, we in the next, we are recommending to the portfolio committee that the portfolio committee should take into consideration that if the provision of a written consent is narrowly considered in polygamous marriages, and in particular as it relates to the royal family, such may have an adverse impact on how kings and queens are identified in customary law, and that therefore it is our considered view that the committee must seek to minimize the unintended consequence and ensure that the proviso or the issues related to written consent should be left to the royal family itself, and that it is necessary, in our view, to retain the proviso in line with the traditional and Khoisan Leadership Act. Chair, those are our submissions, Chair. Thank you.
Thank you, Advocate Malikate. I must also note that both the Minister and the DG of COCTA are also attending the same meeting that DG Makode is attending, and they've tendered an apology. The apology is noted and also considered. Can I now invite the COCTA?
Good morning, and thank you, Honorable Chairperson of the committee, honorable members of the committee, colleagues from the two departments, and everyone on the platform. I am Shoki Mukhaladi from the Department of Traditional Affairs, and I'm the DDG responsible for research, policy, and legislation, and I'm representing the department. As the Honorable Chair, you have noted the apology from our minister and our DG. I am with my colleagues from the department, and I also have one colleague, Advocate Kagiso Mapalle, and she will be taking the committee through our input or input from the Department of Traditional Affairs on Section 6, subsection 2A of the Marriages Bill, as we have been advised in the letter that we received from the committee. So I will hand over to Advocate Mapalle, Honorable Chairperson. Thank you.
Is Advocate Mapala in the meeting?
Yes, as far as I know, she is. But then it seems there's a problem because she is not responding. But then maybe, I don't know. Advocate Mapalle, may you please proceed?
I'm in the meeting, DBG. I think I was muted. My apologies. Good morning, Chairperson and Honorable Members of the Committee. If I can please confirm that the presentation is visible on the screen.
Yes, we can confirm that. Thank you.
Okay, thank you very much. I will be presenting the briefing by the Department of Traditional Affairs and input on Clause 6 2A of the Marriages Bill. On your screen is the presentation outline, which is self-explanatory. And in terms of the purpose, is for the Portfolio Committee to note the Department of Traditional Affairs input regarding the perceived unconstitutionality of Clause 6 2A of the Marriages Bill 2023 in the context of polygamous customary marriages within royal families. The Minister of Traditional Affairs received an invitation from the Portfolio Committee on Home Affairs on consultations regarding Clause 6 of the Marriages Bill 2023. And accordingly, this presentation focuses on Clause 6 2A of the Marriages Bill, which speaks to the consent requirement in polygamous customary marriages of royal families. Chapter 3 of the Marriages Bill, Chairperson, outlines the requirements for monogamous and polygamous marriages. And in terms of the requirements for polygamous marriage, Clause 6 2A of the draft bill provides that a husband in a marriage who wishes to enter into a further marriage after the commencement of this act must obtain written consent from his wife, or in the case where there is more than one wife, his wives, as the case may be. And the proviso there is that in the case of the royal family, the consent must be in accordance with the customs and traditions of such family. In providing its inputs, the department noted that the Office of the Chief State Law Advisor was unable to certify the draft bill and provided an opinion as contemplated in Rule 2793 of the Joint Rules of Parliament. The Office of the Constitutional and Legal Services Office of Parliament agreed with this opinion and advised the Portfolio Committee accordingly. Now, both the opinions that were provided to the Portfolio Committee argue that the proviso in Clause 6 2A of the draft bill may be unconstitutional as it differentiates between women married in royal families and women married outside of royal families, in contrast to Sections 9 and 10 of the Constitution. The department further noted that the Department of Home Affairs is of the considered opinion that Clause 6 2A of the draft bill, although it may be viewed as unconstitutional, is necessary to preserve the customs and cultural practices in line with Sections 15 and 30 of the Constitution. In view of the above, and in response to the request for written comments on Clause 6 2A of the draft Marriages Bill, we wish to state the following: that in the case of customary marriages within the royal family, the potentiality of polygamy is often realized. A traditional leader is allowed to have more than one wife, but there are, however, rules regarding the conclusion of a customary marriage between himself or herself and the senior wife, as well as his or her other wives. Now, the order and seniority of the wives does not always follow the chronological order of the date of the marriage being concluded, but is reliant on the customary role of the wife, the customs and rituals performed by the royal family in relation to the wife, as well as the role and participation of the community in paying the bride price, as well as the impact that these have on the eligibility to the throne for a future successor. Now, this becomes the nexus of the provision in Clause 62A of the draft bill, where the requirement for consent and its applicability is reliant on the customs and traditions of such royal family. Central, Chairperson and honorable members, to the determination of succession disputes within the institution of traditional leadership in South Africa is the validity of the customary marriage concluded by the incumbent to the position, as well as the processes followed in the selection of the senior wife, who is known as Mahoshi Siantlo Timamollo in the Bapedi, Batswana, Basotho, and Balobedu speaking communities, Undlunkulu in the Amazulu, Amaswati, Amaxhosa communities, and Inkosikazi in the Ndebele communities. Of course, in the Bavenda, as was previously presented in the previous presentation, the Mufumakazi Wadzekiso. Now, the documented text on the history of traditional leadership in South Africa to date not only confirm the centrality of the senior wife to succession issues, but also further highlight the detailed differences between the rules applicable to the processes of concluding a customary marriage with the senior wife and the other wives of a traditional leader. Now, the historical, cultural, and social context of the rules pertaining to the customary law of succession within the institution of traditional leadership in South Africa that have guided both the processes and ultimate selection of a successor find basis on the principle of socio-cultural differentiation between the wives of a traditional leader, which at face value may be viewed as discrimination. In practice, however, this differentiation is aimed at preserving the history, the culture, and the heritage of traditional leadership institutions of these respective communities, and which differentiated practices are not only known, but accepted by members of such communities, often with their direct participation in their preservation. A key and notable example confirmed by the evidence contained in the documentation of customary laws of succession and genealogies by the department is that across all the diverse cultures present in South Africa, the common denominator and exception in the conclusion of a customary marriage with the senior wife of a traditional leader is the contribution by all members of the community in cash or kind towards her bride price. All other wives of a traditional leader who are not the senior wives do not have this as a requirement to the conclusion of their marriages with the traditional leader. Furthermore, Chairperson and honorable members, all the recognized kingships and queenships in South Africa and the previous and current incumbents of such positions legitimacy to the throne were ratified through the validity of the customary marriage of the senior wife from whom they were born, either biologically or sociologically. And this is, of course, dependent on the circumstances pertaining to the royal family in question, and more specifically, the processes which were followed in the conclusion of the customary marriage of the senior wife. Now, this key requirement, which serves as a differentiation between the wives of a traditional leader, becomes the point of contention on the basis of the perceived unconstitutionality as per the legal opinion of the Office of the Chief State Law Advisor. This then, Chairperson and honorable members, presents two parallel and opposing views, which views both find their basis on provisions of the Constitution. The first being that the perceived discrimination leading to unconstitutionality contained in Clause 62A of the draft bill, with the specific provisions pertaining to the obtaining of consent from a wife or wives in the context of a royal family, which are subject to the customs and traditions of such royal family, and are aimed at preserving the customs and cultural practices in line with Section 50, 15, and 30 of the Constitution, which have a perceived violation of Sections 9 and 10 of the Constitution. The second parallel and opposing view is that the upholding of the specific rules, customs, and traditions relating to the conclusions of a customary marriage between the traditional leader and a senior wife, and their impact in determining a successor to a position of traditional leadership. Now, these were upheld by the Constitutional Court in cases such as Bapedi Marote Mamone versus Commission on Traditional Leadership Disputes and Claims, the President of the Republic of South Africa and others versus Prince Mbonisi and others, the Shilobana and others versus Nwametwa case, and which cases relied both on the evidence from reports from the Commissions on Traditional Leadership Disputes and Claims, and these are the Nhlapo, the Dolo, Khatla, and other commissions, as well as oral and expert evidence provided in such court proceedings, which were central to whether such marriages were validly concluded in terms of customary law, and the consent requirement in the context of royal families, together with its perceived unconstitutionality, which is contained in Clause 6(2)(a) of the draft bill. Now, in this slide, Chairperson and honorable members, we look at the justifiable discrimination of Clause 6(2)(a), which we say, in order to arrive at the middle ground or acceptable concession to the matter, it's important to answer the question whether such perceived discrimination is justified or is justifiable. And here we refer to the precedents that, building on the foundation laid by the interim constitution, the final constitution of South Africa recognizes equality as one of the nation's founding values. And in doing so, it highlights it as a value that all the remaining provisions are inherently tangled with. Additionally, equality is incorporated as a legally enforceable right in itself. And the South African Constitution incorporates both an equal protection and a non-discrimination clause. Now, Section 9(1) of the Constitution provides that everyone is equal before the law and has the right to equal protection and benefit of the law. The non-discrimination clause, which is provided under Section 9(3) of the Constitution, enumerates several grounds of non-discrimination. Now, the provision's phrasing indicates that the list is non-exhaustive, and while there is a presumption of unfair discrimination for distinctions made based on the characteristics explicitly listed in Section 9(3), such a presumption does not exist for non-listed grounds. Furthermore, Section 9(5) provides that only discrimination which is unfair is prohibited. And this provision then shifts the burden of justification to the respondent when a distinction is based on one of the listed grounds. So the non-discrimination clause in the Constitution has both a vertical and horizontal effect. The prohibition of unfair discrimination concerns both the state, which is vertical, and private individuals, which is horizontal. And it further entails a positive obligation of the state to prevent or prohibit unfair discrimination by private actors. Now, this obligation requires the state to enact national legislation which targets unfair discrimination. And the equality provision also authorizes positive discrimination as Section 9.2 serves as basis for legislative and other measures that are aimed at uplifting disadvantaged groups of society. Also, finally, the right to equality is not an absolute right. It is subject to a general limitation provision found under Section 36 of the Constitution, which requires any limitation against the Bill of Rights to be reasonable and justifiable. The Constitutional Court, Chairperson and honorable members, laid the groundwork for its interpretation of equality and non-discrimination in the three cases of Hugo, Prinsloo, and Hodgson. The citations of the three cases that I'm mentioning are listed on the screen below. And in particular, it's the case of Hodgson that provided a comprehensive outline of the court's approach, which has been the basis for the subsequent equality doctrine of the court. Now, the court applies a two-stage test to assess the violation of the General Equality Clause, as well as a multi-layered test to determine the existence of unfair discrimination. The two are related, as the multi-tiered non-discrimination test builds on the two-stage test if the latter did not result in a violation of equality. Now, this test applies to cases concerning direct as well as indirect discrimination. And the court starts by analyzing the General Equality Clause in Section 9.1 of the Constitution. Firstly, the court analyzes whether there is a differentiation between people or categories of people. In a second step, it asks if there is a rational connection between the differentiation and a legitimate government purpose. In the case of Prinsloo, the court specified that this requirement, arguing that the purpose of this aspect of equality is therefore to ensure that the state is bound to function in a rational manner. Now, if the court finds a rational connection, the General Equality Clause is not violated. However, the court continues with the analysis of a potential violation of Section 9.3. And here, the court analyzes whether the identified differentiation amounts to unfair discrimination. If the ground of distinction is explicitly mentioned in Section 9.3, the unfairness of the discrimination is presumed, but the contrary may be established by the respondent. Now, by contrast, if the ground is not explicitly mentioned, the court has to establish the unfairness of the discrimination. And in considering the unfairness of a discrimination, the court considers several factors. And most importantly, it asks whether the discrimination has led to an impairment of their fundamental human dignity or constitutes an impairment of comparably serious nature. Now, if the court finds that an infringement of the General Equality Clause or an unfair discrimination, it undertakes a justification analysis under Section 36 of the Constitution. And now discrimination can only be justified if it is justifiable in an open and democratic society. The court applies this test by evaluating the purpose and effect of the legal act vis-a-vis the extent of its infringement of the right. Now, this is an integral part of the test, as the presumption of unfair discrimination can be rebutted. Chairperson and honorable members, it is therefore the department's submission that the provision of Clause 6.2a of the draft bill is both necessary and justifiable against the perceived discrimination as it pertains to the consent requirement in the conclusion of polygamous customary marriages of royal families, insofar as it relates to succession method of traditional leadership positions and its institution. Now, in terms of recommendations, Chairperson and honorable members, it is recommended that the Portfolio Committee notes the Department of Traditional Affairs inputs regarding the perceived unconstitutionality of Clause 62A of the Marriages Bill 2023 in the context of polygamous customary marriages within royal families, in the context of inheritance and succession matters within the institution of traditional leadership. Thank you, Chairperson and honorable members.
Thank you very much for the comprehensive presentations, both the COCTA and the Home Affairs. Members, I'm not sure if the Parliamentary Legal Service want to comment or they will respond later before I invite members. What I wanted to test their comment on these two presentations, or they won't allow the committee to come back to them later. Can I invite the committee? I'm sorry, the legal team.
Good morning, Chairperson. Good morning, honorable members. My name is Zingisa Zenani. I am with my colleague, Mr. Lekgotlo Shukwa. We are from Parliamentary Legal Services. Chairperson, we have had a discussion with Advocate Malakate previously, and he did raise the case law that he is repeating today. And in our engagements, we highlighted the fact that the case law that he is referring to did not deal with the issue of equality of women, and in particular in marriages. Furthermore, I have listened to his presentation. I have listened to the presentation by my colleague from COCTA. My colleague from COCTA speaks of perceived unconstitutionality, perceived discrimination, perceived violation, yet she is already in the terrain of FASCAN. At FASCAN, you have already established that there is a discrimination. Then at FASCAN, you are trying to justify why the discrimination should stand. So it cannot be a perceived discrimination if you are already at FASCAN. Secondly, none of the two presentations that have been made in this committee by my colleagues speak to the decided constitutional court case of Mayelane. Mayelane spoke to the issue of consent. The case law that our colleagues rely on do not speak on the issue, do not speak on the balancing of the rights to equality and rights to cultural practices. Secondly, the presentations that have been made by our colleagues do not go to the provisions of section 211 subsection 3 of the Constitution, which says that the courts must apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. The case of Misuzulu Azulu speaks to that balancing, to say that if customary law is not aligned with the Constitution, then it must be aligned. I do not hear my colleagues speaking to that comment by the court. I do not hear my colleagues saying that the case law that they are presenting before this committee override the decision of the Constitutional Court in the Mayelane judgment. Chairperson, I think we've already presented our view in this regard, and just wish to highlight that we still disagree that the proviso passes the test in section 36. I am with, I understand my colleague from Oxla is also here. I don't know, perhaps because she was also part of this process.
Okay, can I propose so that we are fair to the conversation? And I think members will guide when they deliberate that we we know that the response of Parliamentary Legal Services, or the comments of the Home Affairs in relation to the this clause, I want to propose that the legal team of Parliament and Oxlade does respond on the, I know you've made comments, respond to the COCTA, and that will assist members when we are going to deliberate or consult further to apportion all the three presentations formally. And we know that at least we have a sense of their views carried to opinion on Home Affairs and Home Affairs on the legal parliamentary legal team. So I'll request that you grant a formal response to the COCTA, and then in the subsequent meeting we'll then have your formal response, and I'll request that you send that respond to the COCTA, and then when we come, at least we have a solid conversation and responses that will allow then members to then go and deliberate. And I know COCTA may want attempted to respond, which I'll propose they must not respond now. We'll have it for discussions on the responses when there is you respond to this important paper update that they've presented. So I'm trying to avoid that, members. We get into the direct conversation or responses between our stakeholders. So give them time, and also give members, so that at least when you respond on what you have already commented, members have already gone through the detail, which I think to be supplementary on the issues that you have raised with the Department of Home Affairs, and we have a detailed issues. Let me, the Chief State Law Advisor, you want to make a comment?
Good morning, Chairperson. Good morning, colleagues. Good morning, honorable members. Chairperson, I just want to, I've listened to the presentations both from the department and from both departments, and the arguments which I just want to confirm or to state, to place it on record. I agree with what the Parliamentary Law Advisor said. This matter is a constitutional matter, and if you read Section 1 and Section 2 of the Constitution, all laws must be subject to the Constitution. And the Constitutional Court, being the apex court in our country, they've already decided on a matter that is before us, that's in this bill, a situation of this. The apex court has decided on a matter which has a set of facts, and everything's exactly the same about consent of the second wife. The highest court has made a decision on that, taking into account the relevant and applicable provisions of the Constitution, and has made a decision on that matter. And I think, and that's a Mailani judgment, and I think that's a very important judgment, or the judgment which is instructive in this matter. And I think that judgment should be used as a guidance, or should guide in dealing with this matter. We've listened that the department has raised lots of other judgments, but those court cases, some with the high court cases, some with the lower court cases, those are not instructive in this matter, because this matter deals purely with the consent of the first wife to a subsequent marriage. And that matter has already been decided in the Constitutional Court. And they've dealt with the balancing of rights, they dealt with equality, they dealt with all the relevant applicable constitutional rights, which we have discussed and unpacked in our previous opinions, and as well as in our previous presentations. So Yeah, and the presentation by the departments they didn't cite their judgment. No reference was made to the judgment, and what they cited and what they referred to was not core, was not central to the issue in this matter before us. And I think that it's important that we do focus on what is before us than to cloud the issues, because that may just create confusion. Yeah, thanks, Chair.
Thank you very much for the comments. Members, can you get your comment? Then I'll briefly go back to
my hand is
legal.
up.
Okay. Honorable, let me note. Oh yeah, Memaji.
Thank you very much, Chairperson. Thank you for the presentations. But Chairperson and the colleagues, I would like us to note these presentations, and we request for the external opinion to test the two opinions from the Department and Legal Services. Secondly, I think we also need to engage with the House of Traditional Leaders for further consultation. Thank you, Chairperson.
Thank you, Memaji. Honorable Ross.
Thank you, Chair. Chair, I think, yeah, one is requesting the State Law Advisor and Parliament Legal to respond to the other presentations. I think it's also important for those other presentations to respond to what the State Law Advisor and Parliamentary Law Advisors have put forward. I know they have mentioned it, but I think it's important that each responds both ways. Chair, I've raised it before. Section 165.5 of the Constitution states that an order or decision issued by a court binds all persons to whom, including organs of state to which it applies. And then Section 167.5 of the Constitution states that the Constitutional Court makes the final decision whether an act of Parliament, a provincial act, or a conduct is constitutional. So that means that we can't have an argument that Parliament needs to make a Section 36 assessment and decide whether to override a Constitutional Court judgment. So we do need to bear that in mind, and it's important that, having received the legal advice which we have, that the stakeholders respond to that, and that's what was supposed to happen with Home Affairs in particular. I mean, COGTA wasn't in that meeting that we have. But Home Affairs would know that is exactly what we requested. Respond to the statement about the Mailani judgment and the King judgment and so forth, and come back with the response. But yeah, I also think that there was a lot of stakeholder engagement, and I'm just surprised. I don't see that coming through here. That we say go back and consult with traditional leaders on that, but surely that was done as part of the development of the marriage bill. There was a long process. There were workshops, stakeholder engagements. And I want Home Affairs to tell us, was there no engagement with traditional leaders on this matter? Because this ended up in the bill. Surely there was extensive engagements with traditional leadership. And I think they should inform us what were the discussions there, what happened? Because we now have a Constitutional Court judgment of our own, and this bill is a response to that. And we're having to continually kick this can down the road, waiting for our, all the different legal advisors to come to some sort of an agreement, Chair. So I think it's important that they respond both ways, that we understand there's a Constitutional Court judgment. I don't understand how one can override that. And I think the DHA and COGTA people should say that, but they should say why we are allowed to override that. But this is also about people. And so I think we need to understand what were the specific engagements with traditional leadership in this regard, because we can go and engage with traditional leadership, but if the Constitutional Court, which has the final say, has had the final say, what are we going to discuss? Thank you, Chair.
Thank you very much, Honorable Ross. Honorable Ngobeni.
Thank you, Chair, and good morning to the colleagues. Yeah, no, I think, we all listened quite intently to both presentations. And, my concern, and I'm not sure if, this is the right platform to raise it, but I do also align my thoughts with the assertions by Honorable Ruas. The issue of consent is particularly, interesting for me. With regards to, the consent of subsequent wives, I don't get the sense that it should be agreeable that all wives have to agree. I mean, the consent in terms of that they must be informed, I didn't get the sense, and I just need clarity on whether all wives, all the existing wives should agree to a subsequent wife. In other words, if there are three wives and the husband wants to take a fourth wife, do the three wives all have to agree that this happens, or how? I need clarity on that. And then, of course, the Marilani judgment is important, in this regard. But what is particularly concerning for me is that the proposed exemption seems to assume that customary processes within, particularly within royal families, can adequately substitute for the express consent of affected wives. However, we didn't get any clear explanation as to whether, has been provided as to whether the views and objections of these existing wives are taken into account. And then, of course, balancing the rights of wives and then succession. I would like to hear also what the outcome of that was, to Honorable Ruas's point around the engagement with traditional leaders. If we just can I just get a clarification on that, because I didn't get that coming through from both presentations. I think the rest has been ventilated. Thank you.
Thank you, Honorable Ngobeni. There's no hand. Can I get the comment from Home Affairs and COCTA? Then we'll outline the process. I see Honorable Jama.
Yes, thank you, Chair. Apologies for that. I've been having some network challenges, but just quickly, I just wanted to align myself with Honorable Maxi. I do think from where I'm seated, I do require a little bit more of some legal opinions. I think the conflicts between the two opinions, I don't think at this point I'm satisfied to be able to make some sort of definitive opinion on the matter. So I would also align myself with Honorable Maxi and some of the things that Honorable Riss also said around like what went wrong. I wouldn't imagine that such a big conflict would come at this stage of the bill. So it would also be good to hear from the department, as Honorable Riss was saying, to just be taken through how we find ourselves here as well. Thanks, Chair. That's all for now.
Thank you, Honorable Jama. Honorable Mtolo.
Thank you, Chairperson, honorable members and members of legal team. We appreciate your presence and legal guidance will provide us a considered dismissal. Chairperson, I support the proposal made by colleagues that we allow more time to consider the illegal advice presented to us given the complexity and sensitivity of the issues involved. It is important that we engage further and obtain additional legal guidance before taking a final decision, Chair. As Member of Parliament, we must make sure that our position is informed by sound legal advice and a full understanding of the implication of the bill. I thank you, Chairperson.
Thank you very much, honorable members. Advocate Malikat, can I get you back briefly and COCTA briefly? Then we then outline how we understand the comments of all members and their recommendations.
Thank you, Chair. What we need to take into consideration that indeed Honorable Ross is correct that when we were developing the white paper on marriages in South Africa, when we dealt with the issue relating to consent, the issues, the proviso that we have inserted is as a result of the consultation and the conversations that was had by the department with the traditional councils and traditional leaders, that there is a need for us to ensure that we do not impact on customs and tradition as it relates to this aspect, requesting written consent from the wife, because there are set rules, and you would have had the COPTA also making the same point that there are set rules and principles that are followed when issues related to identification of kings and queens is concerned. Chair, we also need to be the committee would need to take into consideration that the Mayelane decision does not deal with issues related to consent within the royal family itself. The Mayelane decision, when you read it, it is just generally between a man and or it deals with the circumstances when a man wishes to take to conclude a further marriage, that there is written consent, and that the provision itself in under clause 2 deals with it, takes into consideration that. But Mayelane did not go further to deal with what should happen within the royal family in as far as it relates to the written consent. So Chair, the committee would need to take that into consideration, that it may be difficult to extend the decision in Mayelane to what happens in the royal family, and this is the caution that both ourselves and COPTA would have been making. We do get the concerns being raised by the colleagues from both Oxley and the Parliamentary Legal Services, and we just want to submit, and perhaps it would may be prudent that what the honourable members are raising, that perhaps if the committee is not satisfied with the submissions that we have made, both from ourselves and also COPTA, it may also be prudent to consider whether we need to have the National House of Traditional Leaders to come and make a presentation formally to the committee in as far as it relates to this aspect. Our view is that if we were to narrowly look at the written consent, that in all circumstances that should be required. We are of the view that there may be unintended consequences, and which is what we would need to guard against, and that is the advice that we are giving to the committee, for the committee to consider. Chair, thank you.
Thank you, Advocate COPTA.
Thank you, Chairperson and honorable members. Just piggybacking on what my colleague from DHA has said, we did not ignore the case of Mayelane and the constitutional judgment in that regard. And as he has rightly indicated, the case of Mayelane dealt with consent within the context of polygamous customary marriages that do not take place or are not concluded in the context of royal families. And so to want to take the judgment as is without it having taken due regard to the context of royal families would be a narrow application and have unintended consequences. Firstly, in the preservation of the customs and practices in terms of succession and inheritance within traditional leadership institutions. But also secondly, it has an impact even on the current existing recognized kingships and queenships in South Africa that have also been confirmed by the Constitutional Court itself on the basis of the arguments that the Department of Traditional Affairs is putting forward. And so the Constitutional Court in Milan rightly dealt with consent. But the fact that it did not extend to the context of royal families and the customs and practices that are practiced in the conclusion of a valid customary marriage of a senior wife in the context of traditional leadership institutions becomes a precarious position that, if not handled with care, might lead to unintended consequences, not only for the institution of traditional leadership, but also for the preservation of the customs and practices in terms of customary law that pertain to the rules that deal with succession in succession to traditional leadership that also affect not only the institution itself, but the spouses and children born of such marriages. So we do take due regard to the concerns. We do take due regard to the fact that this was a constitutional court judgment. But I think there needs to be emphasis on the fact that the context and the facts of the Mailani case did not extend to customary marriages of royal families. And that is an important fact to take consent of and cognizant of, because that is what the clause is dealing with. Other sections of the clause deal with consent generally, but this proviso applies to consent within the context of royal families. Thank you, Chair, honorable members.
Thank you very much for the comments and input by members, COCTA, and Home Affairs legal team, and the Chief State Law Advisor. All the comments assist us to have a proper summary for further discussions. We have requested earlier on that the Chief State Law, the Parliamentary Legal Services draw up the response on the issues that have been raised. And secondly, that issue of consultation with the traditional leaders or House of Traditional Leaders, we do know that through the consultation by the department, they may have consulted through all stakeholders. And it is important that we solicit clarity around the subject matter on clause 6 to further. There's nothing wrong to further consult with the traditional leaders, House of Traditional Leadership, as raised by Honorable Machi, but also the concern of Honorable Ross and Honorable Ngobeni, whether they did raise that. And I think it's important that we explore ourselves as a committee to further consult on that space. Secondly, it may be important that and it's a matter we'll take it up with the legal team, because costs will be involved to explore the external legal opinion on this particular matter. And this will allow members, when we have deliberations, at least we have exhausted all areas of understanding, and that will assist us to then begin to have a conversation by the committee and consolidate the report, so that if there are matters that will be raised later, we have exhausted our part as the portfolio committee meeting. I do note expressed views by Home Affairs, COCTA, and the Parliamentary Legal Team and the Chief State Law Advisor on the position of thoughts, but the interpretation to that extent. So I'll propose that we step off this item with that resolution that will further do a consultation with the House of Traditional Leaders, and also explore a way to have an external legal opinion as the committee. It will be an in-committee for us to explore more and invite the 3 or the 4 institutions further. All, I think, raising key issues. So I would suggest that we step off with that understanding and the summary, members. I think that is an appropriate position we should take.
Sorry, Chairperson.
Panel Machi?
Yes, I would like to request that we forwarded the presentations in advance.
Okay.
I've got to receive the presentation earlier, not to see the presentation whilst they are presenting. Thank you.
No, thanks. I think that is a concern that is being raised. I think the administration must take note that members must prepare and go through the details, because they must first also go to consult further through their caucus legal teams and come back to engage in the committee. So it's important that we complement and assist members to have enough opportunity to deal with that. I think we'll close it in that manner. Members, I'm sure with your comments that have been raised on how we must proceed with this. Thanks very much, Advocate Malekate. Thanks very much, COCTA, and your leadership. Thanks very much, Parliamentary Legal Team and the Chief State Law Advisor. We'll now release you on this item. The last item will only request the members of the committee. Thanks very much for submissions.
Thank you, Chair.
Thanks, Chair.
Thank you, Chairperson.
Members, I request Honorable Modise to take the last item. Thank you.
Thank you very much, Chair, and good morning, members. I think the last item on our agenda, Mr. Matonzi, would be the set of minutes. Can you confirm?
Yes, Chairperson, is the two sets of minutes. Minutes of 19 May, where I presented a letter from the Minister of Home Affairs regarding the person from Nigeria who coronated himself as a king in the Eastern Cape, and then and also there was a letter from the Minister of Home Affairs where he designated two officials, one for dealing with civics services queries, and the other one with immigration services queries. And then also there was a letter from the IEC on the impact of Section 24A of the Electoral Act, and then also the issue of voting and voter registration application, the app. And then we also consider the oversight report to Lupompo and the digitization project oversight. Yeah, I think also we also consider the minutes, the outstanding minutes. So these are the people, members of the parliament that were there in the meeting. The minutes were sent earlier on for members to go through them.
Okay, thank you, members. Here are the minutes. Can we get comments and a mover and a seconder for the adoption of the minutes?
Chair, on my side, I move for the adoption. I've gone through the minutes. I think it was a true account on my end. Thank you.
Thank you, Honorable Ngubeni.
Chairperson, I second to move the minutes.
Thank you, Honorable Ntolo. The minutes have then been approved. Can we get another set?
The last set is the meeting where the Department of Home Affairs briefed the committee on the fourth quarterly performance for reports for 2025-26 financial year. And then also the department briefed the committee on the asylum seeker backlog and refusal of new cases. And then we also, we're supposed to consider minutes, but we move those minutes that we just adopted now. These are the members who were in the meeting. This is just a summary of the report that was presented to the committee on the quarterly, as well as the asylum.
Members, can we get comments?
Yes, Chairperson, I move to adopt. Let's adopt the minutes. They are the true reflection.
Thank you, Honorable Mati.
I second, Chair. Honorable Roos.
The minutes are therefore being approved. Those were the two sets of minutes I believe we had to deal with, Honorable Mr. Matonzi.
Yes, Chairperson, is that yesterday we also received we also received a letter. Sorry. Yesterday we received a letter from just an announcement from the Chairperson of International Relations that is addressed to Chairperson and other chairpersons of all these committees here for a joint meeting tomorrow.
Honorable Mati, can you mute?
Thank you. I'm sorry.
Okay. Yeah, I was saying no. This letter is addressed to all these chairpersons for a joint meeting tomorrow between 1 and 2 to discuss the issue of anti-immigration protests that is currently taking place across the country. The reason being that COCTA is planning a symposium around the 26th of June to inviting different stakeholders to discuss this issue. So they are asking for a meeting tomorrow. I have this invitation, and also they have developed a concept paper which I can send to members. So the meeting is supposed to be tomorrow between 1 and 2 o'clock. That's all from my side, Chair.
Thank you for that announcement, Mr. Matonzi, and we know hopefully we will get any information from the chair. Thank you very much, members. I think those were the last items that were on our agenda for this morning's portfolio committee. We appreciate your commitment and your attendance. Thank you very much. The meeting stands adjourned.
You.
Thank you, Chairperson.
Thank you.
Thank you, Chair. Bye-bye.
Thank you.
Kunobhala uncayane siyacela ningamnikezi inkinga kakhulu ma-comrade.
Can you? Yeah, I know you. Yeah, but remember I told you that no, the term is coming to an end now. I think we've got only 2 meetings. So I said I'll send you the 3rd term program. Yeah, so we have not done the 3rd term program. Yeah, not yet. So it has to be, okay, how it works, we do a 3 months program. So then the 3 months program is ending now. I just finished a meeting today, and then there's another meeting with the IEC on Friday. Therefore, next week is recess because of yeah, of the June 16. Then on the 23rd, that's when we are going to have one meeting. Then from there, they go on recess. Yeah, so that's why. Oh, okay, okay, all right. Mm. But you don't. But do you check the Z list? No, no. But on the yeah, but we before we go on a meeting, we update the Z list. Yeah, the Z list is updated. If you go and check now, this meeting is on the Z list. If you go, yeah, the Z list is updated daily. Then the Friday meeting, yeah, the Friday meeting is on the as well is updated the Friday, this coming Friday. And it's going to be on YouTube as well. You can just Google YouTube, check on the you see most meetings they indicate the venue. Ne? Yeah, so for meetings that are on Zoom, then they automatically being broadcast on YouTube. Mm. Yeah, yeah. They are always on YouTube. Yeah, yeah, those are in Parliament. Yeah. Mm. All right. Okay. Sure, sure. Bye.